Resuming debate, the Honourable Member for Edmonton, St. Albert.
Thank you very much, Mr. Speaker, and it's certainly a pleasure for me to rise and speak against the motion that was proposed by the Honourable Member for Windsor-Tecumseh. As I indicated in my last questioning to the member for Mississauga, I believe that it was important, if not fundamental, that this is really a question of privilege, is what the member for Windsor-Tecumseh is raising, and he tried to raise it in committee yesterday. And you'll undoubtedly be aware, Mr. Speaker, that there's a principle of parliamentary law when issues of privilege are raised. They ought to and need to be raised at the first available opportunity. And I would suggest that window has lapsed. If the member for Windsor-Tecumseh was concerned about this lack of information that he had requested and allegedly, and I use that word deliberately, allegedly had been promised in a timely manner, that ought to have been raised at committee, and it ought to have been raised when the bill was under consideration clause by clause. I am a member of the Justice Committee, and I want to state emphatically on the record that the member for Windsor-Tecumseh made no such objection. When this bill was before committee, he made, for clause-by-clause consideration, he made no objection, made no attempt to adjourn the proceedings, no attempt to adjourn clause-by-clause consideration until this information and this from the Commissioner of Corrections was available. So I would suggest that his motion is not meritorious. Moreover, I mean, I've listened to a number of members from the member from Windsor-Tecumseh's party, from his caucus, all indicating philosophically their opposition to Bill C-36. I am not even remotely convinced that any member of his caucus, or for that matter, any member from the Bloc Québécois, would be inclined to alter their vote one way or another with respect to that information. They've stated that they're against C-36. They're in favor of the faint-hope clause, and therefore nothing turns on this information that was allegedly promised before clause by clause. So, Madam Speaker, Canadians want this legislation. Our constituents, certainly my constituents, have written, they've emailed me, they've called me, and they're in favor of Bill C-36, the Serious Time for More Serious Crime Act, which, as you know, and because you followed this debate, will repeal the so-called faint hope clause for those who commit murder after the date of proclamation of this act. But it'll do more than that, Madam Speaker. It'll also toughen the procedural requirements to make a faint hope application for the approximately 1,000 already convicted murderers now serving life sentences in Canada prisons who presently have the right to apply for faint hope or will have the right to do so after serving 15 years. I'm pleased to note, Madam Speaker, that after hearing from several of the witnesses at the Standing Committee, which reported Bill C-36 back to this House with a few highly technical amendments that will make the harmonization of the English and French versions of the bill more synchronized. Madam Speaker, allow me to recap some of the substantive criminal code amendments contained in Bill C-36 for the benefit of all honourable members so that they understand the need that we need to have this legislation passed in a timely manner. As most members will be aware, high treason and first and second degree murder are all punishable by life imprisonment with the right to apply for parole after a stipulated period of time. Section 745 of the Criminal Code stipulates that the earliest parole eligibility for those convicted of first degree murder and high treason is 25 years. It is also 25 years for second degree murder where the murderer has been convicted of a prior first or second degree murder or an intentional killing under the Crimes Against Humanity and War Crimes Act. Otherwise, Madam Speaker, the parole ineligibility period for second degree murder is automatically 10 years and can be up to 25 years as determined by the judge under Section 745.4 of the Criminal Code. Serving up to 25 years in prison without being eligible for parole is obviously a very long time, and deliberately so, Madam Speaker, for murder and high treason are two of the most, and I would suggest the most, serious crimes in Canada's criminal law. Nonetheless, the faint hope clause regime provides a mechanism for offenders to have their parole eligibility period reduced so they serve less time in prison before applying to the National Parole Board for parole if their faint hope application is successful in the first instance. Madam Speaker, the current Faith Hope Clause process is set out in Section 745.6 and related code provisions and has 3 stages. Firstly, an offender must convince a judge from the jurisdiction in which he or she was convicted that the application has a reasonable prospect of success. The courts have already told us that there is not much of a hurdle, and so almost all applicants are able to go on to the next stage. Secondly, and importantly, if the judge is convinced the applicant can bring an application to a jury of 12 ordinary Canadians whose role is to decide whether to reduce the applicant's parole and eligibility period. This decision must, Madam Speaker, be a unanimous one. And thirdly, if the applicant is successful with the jury, he or she may then apply directly to the National Parole Board. At that point, the applicant will have to convince the board that, among other things, their release will not pose a danger to society. Madam Speaker, the Faint Hope regime has been around since 1976 and was concurrent to the abolition of capital punishment. The data indicates that between 1976 and the spring of this year, there have been a total of 265 Faint Hope applications. That is an average of 8 applications per year. Of the 256 applications, 140 obtained reductions in their parole eligibility periods. Thus, 103 applicants with 25-year ineligibility periods obtained reductions of 1 to 10 years, and 37 applicants whose ineligibility periods ranged from 15 and 24 years obtained reductions of 1 to 5 years. Ultimately, the National Parole Board granted parole to 127 applicants. That's early parole. In short, Madam Speaker, nearly half of the 265 Faint Hope applicants were ultimately granted parole before the expiry of their otherwise parole and eligibility periods imposed upon them by the court and by the judge at the time of their sentencing. The existence of the Faint Hope regime and the high success rate of applicants has led to a great deal of public concern, and it is for this reason that I'm speaking against the amendment, so that this matter can come to a vote and the Parliament can express its will. This concern is especially strong among victims advocates groups. This has in turn led to a series of amendments to restrict access to Faint Hope and to make better arrangements for the needs of the families and the loved ones of murdered victims. Thus, the government introduced amendments to the Faint Hope Clause regime in 1995, which came into force in 1997, and it did toughen the application procedure. And in 1999, Madam Speaker, the Criminal Code was amended again in response to the concerns set out in the report of the Common Standing Committee on Justice and Human Rights, a voice, not a veto. As a result, at that time, Section 745.01, and it amended the code to allow a judge sentencing someone convicted of first or second-degree murder or high treason must state for the record and for the benefit of the surviving victims or their representatives the existence and the nature of the Faint Hope regime.